Okay, so the first case for today is Bailey versus West, and as you'll recall, the underlying facts look a little bit like this. There was a horse, and there was a dispute about who owned the horse. And what happened was West informed his trainer, West, who is going to be the defendant in the case, informed his trainer that basically he didn't want to take care of the horse. And the trainer told this van driver, Kelly, that basically to return the horse to the seller. Well, the seller wouldn't take the horse. And so the van driver, Kelly, takes the horse to Bailey's. Bailey cares for the horse for 4 years. He then sues for recovery of his expenses. The trial court gives 4 months of expenses. And then the appellate court reverses. So why don't we just get started? What would you say the two different issues are, Caitlin, in this case?
The first issue is whether there was a contract implied in fact. And the second issue is if there wasn't a contract implied in fact, was there a quasi-contract?
A quasi-contract, sometimes called a contract implied in law. So what is a contract implied in fact?
A contract implied in fact is a contract that's not written or oral. It's inferred by the facts of the situation.
Right, exactly. So you can see, if you look on page 12, right, that this is what the trial court found. He said, look, Kelly and hence, even though he knew there was a controversy surrounding the ownership of the horse, he, meaning Bailey, was entitled to assume that there's an implication here that I am to take care of this horse. So what happened was when the van driver drops off the horse, the argument the plaintiff is making is that, hey, that's equivalent to saying, hey, board this horse and I'll pay you. And then when he began to board the horse, that's the equivalent of saying, look, I've accepted your offer to basically board the horse, and so we have a contract implied by conduct. Now, online student, is a written contract required in order to have a contract?